Testing, testing, one, two, three. Testing, testing, one, two, three. Microphone test, one, two, three.
cases, all with recommendations for decertification from the Peace Officer Standards Accountability and Advisory Board. The meeting is called to order. Mr. Knapp, would you please call the roll, sir?
Yes, Mr. Chair, thank you. Good morning, Commissioners. Barcelona. Braun.
Here.
Brazil.
Here.
Cooper. Doring.
Here.
Duggan.
Here.
Yule. Gordon.
Here.
Johnson.
Here.
Long.
Here.
Moodian.
Here.
Moon.
Here.
Nieto. Rodriguez.
Here.
Terrio.
Here.
And Woolry.
Present.
13 present.
I believe an accident on I-5 has caused Mr. Barcelona and Mr. Cooper to be delayed, but they should be here shortly. Before we begin, I would like to introduce Peace Officer Standards and Accountability Board and Commission Counsel, Deputy Attorney General Christopher Beatty, and to my right, of course, Post Executive Director Manny Alvarez. We'll begin with public comment. This is the time set aside for members of the public to comment on items on our agenda or not on the agenda, but under our jurisdiction. Public comment on the specific peace officer cases to be heard today will be heard at the time that we hear that case. So not at the public comment period right now. Pursuant to commission policy, I will manage the public comment period in deference to the commission's workload, and up to 15 minutes is reserved at each meeting prior to the agenda beginning for public comment. Members of the public are asked to limit remarks to 3 minutes each. If multiple people wish to speak on the same topic, I may ask that you limit remarks to no more than 1 minute. Pursuant to commission policy, I may conclude the public comment period if many people are voicing similar statements and the 15-minute public comment period has expired. And please be advised, we cannot take action on items that are not on the agenda. Finally, this meeting is being transcribed, recorded, and webcast. So please speak slowly and clearly so your comments may be accurately recorded. Does anyone wish to address the commission? Seeing none, we will move on. For the 4 cases we will hear today, we will review only the facts and evidence presented by the Peace Officer Standards Accountability Division and the recommendation of the Peace Officer Standards Accountability Advisory Board. The commission shall consider only the facts the division believes can be proven at a subsequent evidentiary hearing before an administrative law judge. The commission will entertain arguments as to whether or not those facts, as presented by the division, demonstrate a high probability that serious misconduct, as defined in Penal Code Section 13510.8 and Reg 1205, occurred. Remind you that this is not an evidentiary hearing. The rules of evidence do not apply. Evidence is not formally admitted into the record. There is no need to make objections, and objections will not be ruled upon. During and after the conclusion of each post-law enforcement consultant's case presentation, the commission may ask questions, followed by public comment from the subject officer and or their counsel, followed by comments from members of the public. Commissioners may, of course, ask questions at any point. The commission may opt to go into closed session deliberations after cases have been presented. After reconvening into regular session, motions will be considered. Our first case today, 2311370, Jose Zavala, and 2311373, Julio Quintanilla. The Peace Officer Standards and Accountability Board unanimously voted to revoke certification for both officers. Post Law Enforcement Consultant David Sieber and Carrie Woolley, Post Legal Affairs Bureau, will now present the case involving officers Zavala and Quintanilla, who at the time of the events at issue were and still are employed by the LAPD. Mr. Sieber, Ms. Woolley, the floor is yours.
Morning, Chair. Good morning, Commissioners. My name is Dave Sieber. I'm a law enforcement consultant assigned to the Professional Conduct Southern Bureau. I'm here today to present post case number 2311370 involving Los Angeles Police Department Officer Jose Zavala and post case number 2311373 involving Los Angeles Police Department Officer Julio Quintanilla. These cases are associated with a single officer-involved shooting incident involving allegations of serious misconduct arising from Officer Zavala's and Officer Quintanilla's use of force, which resulted in the death of an adult male, whom I will refer to as the victim throughout this presentation. The division found reasonable grounds to believe that Officer Zavala and Officer Quintanilla engaged in serious misconduct in violation of Penal Code Section 13510.8 B3, specifically alleging that Officer Zavala and Officer Quintanilla engaged in physical abuse, including but not limited to the excessive or unreasonable use of force during an officer-involved shooting incident on December 18th, 2021. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 13510.85A4, this matter was heard by the Peace Officer Standards Accountability Advisory Board on April 15, 2026. Following the conclusion of that hearing, the board voted to recommend revocation of Officer Zavala's and Officer Quintanilla's post certifications. The division now presents this matter to you for consideration of suspension or revocation. As required by Penal Code 13510.85A5, the record of that proceeding is before you, which includes the agenda and the attachments from that meeting, a transcript of the relevant portions of the hearing, and the recommendations of the board. If the matter was heard in closed session by the board, Commission Counsel will be able to advise you with respect to those proceedings. The law requires that your review be limited to the record before the board, which is now before you and has been available for your review. To assist you in your review of the record, I will take you through the case as presented there. As the record shows, I presented the case before the board substantially as follows. It is the division's determination that clear and convincing evidence exists to demonstrate that Officer Zavala and Officer Quintanilla committed an act of serious misconduct as set forth in California Penal Code Section 13510.8 on December 18, 2021. Specifically, the division has determined that Officer Zavala and Officer Quintanilla committed the following act of serious misconduct. California Penal Code Section 13510.8 B3, physical abuse, including but not limited to the excessive or unreasonable use of force. In this presentation, I will present a brief outline of the division's findings regarding this matter. First, I would like to discuss Officer Zavala's background. Officer Zavala began his career with the Los Angeles Police Department on May 26, 2009. On October 9, 2009, Officer Zavala was promoted to the position of police officer. This position is a peace officer as defined under Penal Code Section 830.1A. Officer Zavala earned a post-basic certificate on January 10, 2011. Next, I will provide a summary of Officer Zavala's prior discipline. As stated in the initial statement of findings on pages 6 through 9, Officer Zavala is the subject officer in 8 allegations of serious misconduct submitted to the division. These allegations include this case and its related civil matter, 2 allegations that Officer Zavala demonstrated bias, which the division closed with no further action as it lacked jurisdiction due to the events occurring before January 1, 2022, and LAPD concluded its investigation before that date. 1 allegation of abuse of power and physical abuse from an incident on April 2, 2021, as well as a duplicate allegation of the same incident. Despite this case being closed with a finding of no further action, LAPD sustained a single allegation against Officer Zavala for his excessive and unreasonable use of a front kick while dispersing a crowd. Ultimately, LAPD's personnel complaint investigation resulted in a 5-day suspension with loss of pay and benefits. Lastly, 2 cases from 2024, which involve allegations that Officer Zavala engaged in abuse of power and bias, were both closed with no further action. The division would like to note that these 2 cases were identified as unassigned in our initial statement of findings, but however, since then, they've been adjudicated. In addition, a review of Officer Zavala's LAPD personnel file indicated that on February 15, 2015, he was involved in a non-categorical use of force when he and his partner arrested a prowl suspect for a warrant. During the booking process, the complainant punched Officer Zavala in the jaw without warning. In response, Officer Zavala initiated a non-categorical use of force, striking the complainant 8 times with his fists. The complainant received facial injuries and was transported to the hospital for medical treatment. After the treatment, officers walked the complainant to their patrol vehicle, at which point he attempted to flee, resulting in a second non-categorical use of force. As a result of the collective circumstances and a complaint by a civilian witness, LAPD initiated a personnel complaint investigation on Officer Zavala. The investigation resulted in 5 allegations of misconduct, 2 of which were sustained, for Officer Zavala's unauthorized use of force and for his use of tactics that substantially deviated from department tactical training. The LAPD personnel complaint investigation found that Officer Zavala's use of force was necessary and that his first two punches were within policy. However, the investigation found that he let his emotions lead to excessive force when he followed up with punches 3 through 8. Ultimately, Officer Zavala received a 15-day suspension with a loss of pay and benefits. This incident occurred before January 1, 2024, and therefore was not actionable by post. Now I'd like to discuss Officer Quintanilla's background. Officer Quintanilla began his career with the Los Angeles Police Department on February 22, 2016. On August 7, 2016, Officer Quintanilla was promoted to the position of police officer. This position is a peace officer as defined under Penal Code Section 830.1A. Officer Quintanilla earned a post-basic certificate on September 27, 2017, and a post-intermediate certificate on September 23, 2020. Lastly, I will provide a summary of Officer Quintanilla's prior discipline. As summarized in pages 6 through 13 of Officer Quintanilla's initial statement of findings, the division has received 20 allegations of serious misconduct involving Officer Quintanilla. These allegations involve this case, its related case, and a duplicate allegation. This case, its related civil case, and a duplicate allegation. 2 allegations involving abuse of power and bias, which the division closed as it lacked jurisdiction due to the events occurring before January 1, 2022, and because LAPD concluded its investigation prior to that date. 1 allegation that Officer Quintanilla demonstrated bias and used excessive force from 2023, which LAPD found to be demonstrably false. 4 allegations that Officer Quintanilla engaged in abuse of power from 2023. LAPD found the complaints were unfounded in 3 of the cases, and Officer Quintanilla was exonerated in the 4th case. 2 allegations that Officer Quintanilla engaged in physical abuse, excessive force in 2023 and 2024. LAPD determined that the complaints were unfounded in part. The officer's actions were exonerated, and the complaint was demonstrably false. Lastly, there were 8 allegations that Officer Quintanilla demonstrated bias, 6 from 2023, 1 from 2024, and 1 from 2025. LAPD determined that 6 of the complaints were demonstrably false and the remaining 2 were unfounded. The division closed these cases following a determination that there was insufficient evidence that serious misconduct had occurred. In summary, the division closed these 17 allegations of misconduct after finding that there was insufficient evidence that Officer Quintanilla engaged in serious misconduct. A review of Officer Quintanilla's LAPD personnel file indicates that he was involved in 13 non-categorical uses of force, all of which were adjudicated as in policy. Additionally, Officer Quintanilla was involved in 7 vehicle pursuits. 6 of the pursuits were adjudicated as in policy, and 1, which occurred on July 6, 2021, resulted in a sustained finding and a penalty of an admonishment. Now the division would like to provide the factual basis for the captioned use of force involving Officer Zavala and Officers Quintanilla. On December 18, 2021, at approximately 16:54 hours, Communication Division received a call that the victim had walked out of his residence holding a kitchen knife and was threatening members of the community. The victim is described as an adult male, standing 4 foot 9 inches tall and weighing approximately 98 pounds. According to a relative of the victim had been drinking alcohol and using narcotics since he was 18 years old, causing what the relative described as an altered state of mind. Approximately 17:01:31 hours, a sergeant from LAPD's Newton Gang Enforcement Detail, hereinafter referred to as the incident commander, was first to respond to the call. The incident commander arrived on scene, exited his patrol vehicle, and attempted to communicate with the victim, who was sitting idle on the steps in front of an apartment building located near the victim's own residence, holding the knife in his right hand with the blade pressed against his neck. We can put up slide 2, just give you an idea. This is the location. The staircase there is where the victim was sitting, and he came from a residence to the east, to the left of that red building on the corner. At 17:02:05 hours, Officer Zavala and his partner, Officer Quintanilla from LAPD's Newton Gang Enforcement Detail, followed by 2 additional officers from LAPD's Newton Patrol Division, responded to the attempt suicide call for service and contained the victim. Officers Savala and Quintanilla established a perimeter position to the west of the victim and were designated by the incident commander as lethal cover officers. 17:03:02 hours, the victim placed the knife blade against the side of his throat, prompting multiple officers to yell, "Don't do it." The incident commander directed one of the Newton Patrol Division officers, hereinafter referred to as Officer 1, to deploy his less lethal launcher. However, he withdrew the command before Officer 1 could execute the order. Another officer from LAPD's Rampart Patrol Division arrived on scene in his patrol vehicle. The incident commander directed this officer to join the arrest team. 17:03:35 hours, the incident commander retrieved a ballistic shield from his patrol vehicle. The incident commander yelled to Officers Savala and Quintanilla, "You still got lethal coverage right here." For the next several minutes, Officer Savala and Officer Quintanilla and the incident commander alternated, communicating with the victim. Moments later, the victim stood, held the knife to his throat, and gestured the sign of the crucifix across his chest with his left hand. The incident commander directed Officer 1 to deploy his 40mm less lethal launcher by announcing, "40, stand by." At 17:04:06 hours, Officer 1 discharged one 40mm round at the victim from a distance of approximately 30 feet. The round struck the victim in the abdomen but did not appear to have an effect. The victim walked down a short flight of steps towards officers and then sat idle on the bottom step while continuing to hold the knife against his throat. Put up just a brief timeline of events in case I go too fast so you can follow along. There'll be a couple slides just detailing the dates and times. At 17:05:36 hours, body-worn video recordings captured officers alerting one another that a bystander, too close. You got it. Got it. The incident commander yelled, "Hey, stay right there, do not come out." Additional officers warned the bystander to stay inside and to move away from the windows. The bystander complied with the officer's orders and remained inside the building with the door closed. The victim appeared oblivious to the presence of the bystander, who was inside the apartment building behind him. Two additional Newton Gang Enforcement Detail officers arrived on scene. One of the officers deployed a shotgun, positioning himself as a lethal cover officer alongside Officer 1. The other officer deployed a less lethal beanbag shotgun and was directed by the incident commander to move to the west side of the containment perimeter to provide less lethal cover for Officer Savala. The incident commander and Officer Zavala continued alternating commands to the victim. The incident commander utilized the patrol vehicle's public address system to communicate his commands. At 17:10:17 hours, the victim stood up, removed his hat, and held the knife above his shoulders while looking east towards members of his family who were standing behind the containment perimeter. The incident commander announced, "Get ready," while he transitioned from the passenger side of his patrol vehicle to the driver's side where Officer 1 had taken cover. The incident commander announced 40-40 up. After standing, the victim took 4 slow steps forward, turned to the left, his left, but then yielded to the officer's commands to stop. Contemporaneously, Officer 1 announced 40 stand by as the incident commander instructed him to fire the less lethal launcher. Officer 1 fired one 40mm round from a distance of approximately 22 feet, impacting the lower right side of the victim's torso. Approximately 0.382 seconds after the 40mm less lethal projectile was fired, Officer Savala discharged the first of 3 rounds from his service pistol from a distance of approximately 25 feet and behind the driver's side door of his police vehicle, striking the victim. Approximately 0.322 seconds after Officer Savala discharged his 3rd round, Officer Quintanilla fired a single round from his service pistol from a distance of approximately 28 feet and behind the passenger side door of his police vehicle. The victim fell to the ground and was subsequently detained. The victim received medical aid and was transported to the hospital, where he ultimately succumbed to his injuries. On December 21, 2021, the Los Angeles County Coroner's Office performed a post-mortem examination of the victim. The report indicated that the victim sustained 3 gunshot wounds, 2 to the torso and 1 to the neck. Ultimately, the report concluded that the victim's death was a result of a gunshot wound to the torso. LAPD's Force Investigation Division investigated the officer-involved shooting, and the results were conveyed to the LAPD's Use of Force Review Board. The Use of Force Review Board was critical of Officer Zavala's and Officer Quintanilla's perception of an immediate threat and found that their actions were not objectively reasonable, proportional, or necessary. A subsequent department-initiated personnel complaint investigation reached a sustained finding of out-of-policy administrative disapproval regarding Officer Zavala's and Officer Quintanilla's use of force. The Chief of Police did not refer Officer Zavala or Officer Quintanilla to an LAPD Board of Rights hearing. Ultimately, Officer Zavala received a 10-day suspension with a loss of pay and benefits, and Officer Quintanilla received a 5-day suspension with a loss of pay and benefits. Later, on February 3rd, 2023, the victim's family filed a civil complaint which initiated a second LAPD personnel complaint investigation, alleging Officer Zavala's and Officer Quintanilla's excessive use of force. This investigation ultimately determined that the allegation was unfounded for both officers. However, on March 18, 2025, the Los Angeles City Council voted to authorize the city attorney to expend up to $8 million to settle the victim family's wrongful death lawsuit, which was filed in the U.S. District Court for the Central District of California. As of today, the Los Angeles County District Attorney's Office's Justice System Integrity Division has not reached a charging decision and continues to review this incident with the assistance of an independent police oversight firm. The facts I've just recited support the division's finding that Officer Zavala and Officer Quintanilla were involved in serious misconduct, specifically physical abuse, including but not limited to the excessive or unreasonable use of force. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there's a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Officer Zavala's post-basic certification and Officer Quintanilla's post-basic and intermediate certifications be revoked or suspended based on the following. After a review of the evidence developed in LAPD's Force Investigation Division and Personal Complaint Investigation, multiple body-worn video perspectives of the incident, and an analysis of California Penal Code Section 835A and the 2025 U.S. Supreme Court decision in Barnes versus Felix, the division concludes that Officer Zavala and Officer Quintanilla engaged in serious misconduct as defined in California Penal Code Section 13510.8 B3 and Commission Regulation 1205A3. Physical abuse, including but not limited to the excessive or unreasonable use of force. The division's assessment is supported by the following findings. The victim was contained and remained no closer than approximately 22 feet from any officer. Once contained, the victim posed a danger only to himself. The victim's demeanor was not particularly threatening. The victim did not pose an imminent threat to the officers who were positioned behind police vehicles, nor to members of the public who were located outside of the containment perimeter. The victim was slow to respond to verbal commands and less lethal force, suggesting the presence of a mental or physical health condition, cognitive impairment, or the influence of a controlled substance. And lastly, at the time deadly force was utilized, the victim had complied with officers' commands to stop. Officer Zavala and Officer Quintanilla effectively used distance and cover to create time and space in conjunction with de-escalation measures. However, they initiated deadly force before exhausting available less lethal options. The division determined that Officer Zavala and Officer Quintanilla failed to meet the requirements set forth under California Penal Code Section 835A C2, which limits the use of deadly force to circumstances in which it is necessary to defend against an imminent threat of death or serious bodily injury. Additionally, the division requested an independent subject matter expert opinion from Robert Handy of Tri-Chief Consulting Services. The subject matter expert concluded that Officer Zavala's and Officer Quintanilla's use of deadly force was inconsistent with the tactics being directed by the incident commander and was not based on an objectively reasonable belief that the victim posed an imminent threat of death or serious physical injury to the officers or others. Rather, the force was precipitated by the danger the victim posed to himself, which does not satisfy the statutory threshold for deadly force. Based on its investigation and after considering the facts enumerated in Title 11, California Code of Regulations 1213A, the Peace Officer Standards Accountability Division determined that Officer Zavala and Officer Quintanilla failed to meet the requirements set forth under California Penal Code Section 835A C2. Officer Zavala's and Officer Quintanilla's conduct demonstrated a disregard for public safety and their conduct was inconsistent with the duties and responsibilities of a peace officer. Accordingly, the division finds that Officer Zavala's and Officer Quintanilla's actions constitute serious misconduct, warranting the revocation or suspension of their post certifications. I'd like to now present the commission with three perspectives of captured body-worn video devices from Officer Zavala, Officer Quintanilla, and Officer 1, along with a corresponding timeline of the aforementioned events. Following the videos, I'll close with some statements. We queue up the first video.
¿Ok? Mira, mírame a mí, ¿ok? Mira, pon el cuchillo al lado. Mírame a mí, señor. Mira, señor. Señor. Hey, Sarge, let me keep going. Hey, Sarge, let me keep going. He's dropping it.
Drop it on the ground. That's it. That's all I need you to do. Okay? Please drop it on the ground, okay? Just put it down, dude. That's all you gotta do. Just drop it down. Drop it down on the ground. Just put it on the ground, alright?
Stop right there. Stop. Shots fired off any time. Shots fired off any time. Put it up.
That's a 1 minute excerpt of approximately 10 minutes of de-escalation measures. If we can go on to Officer.
Okay?
Drop it on the ground. That's it. That's all I need you to do. Please drop it on the ground, okay? Just put it down, dude. That's all you gotta do. Just drop it down. Drop it down on the ground. Just put it on the ground, alright?
Don't walk over here. Don't. Shots fired. Officer needs help. Put it out.
And lastly, this will be to the east from Officer 1, who had deployed the 40 millimeter. You can see through the windshield and the door frame there, you see Officer Zavala in the background.
Units to respond to 27 and goes into block northbound traffic, 12 and Adams, block westbound traffic, code 3. 100%, bro. Drop it on the ground. That's it. That's all I need you to do. Units from outside unit as well. Please drop it on the ground, okay?
Don't do it, bro.
Just put it down, dude. That's all you gotta do. Just drop it down.
Don't do it.
Drop it down on the ground. Just put it on the ground, alright?
Hey, 40, man! Drop it, 40.
Shot fired? Yeah. We got shots fired. Shots fired.
On, hold the rope.
Would the commission like to see any of the videos again? Would it be helpful? Can you go back to slide 5? We can cycle through that one. There's the positioning. The red line represents the position of Officer Quintanilla. To his right would be Officer Zavala, and then Officer 1 was to the far right east. Following my presentation to the board and is documented in the transcripts before you, Leslie Wilcox, attorney for the Officer for Zavala and Officer Quintanilla, provided public comments to the board as reflected in the transcripts. Additionally, members of the public provided public comments during the board meeting as is reflected in the video recording and transcript of the board proceedings. The board then went into closed session. When the board returned to the open session, it voted unanimously to revoke Officer Zavala's and Officer Quintanilla's peace officer certifications, 6 in favor, 0 against. With that, I'm happy to answer any questions for the commission.
Before we engage questions, I'd just like, Mr. Chandler, would you please note that without objection, Commissioners Cooper and Barcelona have arrived, and add them to the roll, please? Thank you. Sorry, Mr. Seaver. Questions and comments from the commissioners? Commissioner Nieto.
This is more of a comment, and as I was watching the board that takes a look at it, makes a recommendation to us before, and that's what I usually do before this meeting. I've noticed with Los Angeles police officers, there's a bias that is created the way that they do their investigations, and it's not consistent throughout the state. As I was listening to the questions of the other board, the questions about mental illness, they talked a lot about the officer's complaint history. And here's where the bias, in my opinion, is developed. LAPD has a zero policy. You can call and say a Martian landed on my house and it's officer X, Y, and Z's fault, and they will take a complaint and they will investigate it. How they investigate it, that's up to the Los Angeles Police Department. And it will show up on their work history unless it's demonstrably false, because they even talked about a demonstrably false one in I don't know if it was this case or another case. Also, how they handle their use of forces are very different than a lot of other agencies, because they have it'll be out of policy administrative, and having been part of that agency, an out of policy administrative might be because you pulled your weapon out of your holster the wrong way, or you didn't have the right at that point. Although they may find the use of force they find it within the law for LAPD. And so, I don't know how we handle that, because it's just LAPD cases. And Director, you go back and look at them. You can look at how their LOTs, their letter of transmittals, are written. They're very different than the rest of the state, and it does create to me, it creates a bias against officers, because of how they handle discipline and how they handle use of forces.
Thank you, Commissioner Nieto. We are statutorily required to provide the disciplinary record to you all pursuant to the statute. So that is what we provide. Now, whether the LAPD or others investigate or take cases differently, we have to provide that to you one way or another.
Is it possible when we get these agencies to show what their policy says, what their adjudications are? Because even with the Los Angeles Police Department, it in their policies, it shows this is this adjudication. This is the definition for this adjudication. That's within their lexical policies or whatever policies they have. And I'm pretty sure every agency has to have policies on what they've decided their adjudications are for both use of forces and discipline.
If that's the commission's direction, we could certainly provide that either with the ISF, or it could be provided in the ALJ hearing. It would certainly be information that would be provided.
Commissioner Doring.
Commissioner Doring, please.
Again, more of a request, I think, for post on this one when we get these cases. The body camera in this case, the links attached to the agenda are these approximate 1-minute clips of the actual use of force. I know you described the de-escalation that took place prior. I think with any officer involved shooting, all of that is extremely relevant to the case and to the mindset. I think that would be good to include. I know in this incident, LAPD did a critical incident debrief as required by law that's posted online that does show the entirety of the incident prior, when the subject advanced before de-escalation, the original use of force with the less lethal, some radio transmissions that occurred describing this as an assault with a deadly weapon call. I think all of that information is useful for us to hear here at the commission and also the accountability board. And my request would be that that included in the record.
Thank you for the request.
Gordon.
I would also request that the initial 911 call be included when we get these cases. The state of the mind of the police officer is very important. And you can't make that determination based on a 10-second clip. You need exactly what Commissioner Dorn just talked about, but you also need the initial 911 call, the information that they're basing on, because the public safety and what is happening prior to officer arrival and the actions occurring up until that point are also important because that's how they're evaluating the danger to the public. So that is also an important piece. And just an additional request in terms of Commissioner Nieto. I understand providing, what's statutorily required in terms of an officer's discipline record, but I also don't see anywhere where we're providing the officer's evaluations or anything such as accommodations or anything else to show their entirety of their work history. There's no reason that that shouldn't also be provided as long as the department will provide that. But I think it is something that we should be requesting because we should be getting the entirety of the picture of an officer's career and not just, listen, any officer that is doing police work at some point in their career is going to get one or multiple complaints. That is just the nature of what we do. But they also probably have corresponding accommodations and other things that they did in their work history that show that the entire picture of who they are as a police officer. And I think that is an important piece in this evaluation that we're doing with these cases.
Thank you, Commissioner Gordon.
Wagner,
Mr. Chair.
yes, Commissioner Johnson.
Statutorily, I recognize that the civil lawsuit has to be presented. What kind of deference or investigation and review is done into the lawsuit? I realize this didn't go to a jury, it's settled. But what is the investigation that you put into the lawsuit or review of the lawsuit and how it's presented to the commission?
I think I understand your question, Commissioner. Yeah, so we were limited to the documents before us from LAPD. They're both their complaint narrative and their in their disposition. Outside of that, any further evidence would likely be developed in an ALJ hearing or something of that sort. But am I answering your question?
Yeah, just how much effort is in this particular investigation was put into the civil lawsuit and the settlement?
I mean, we communicated with the LADA's office, conducted, federal court records checks, state records checks, because it was filed in federal court. Outside of that, Carrie, did we?
We also checked the city council minutes to look into their closed session hearing and determine when they settled or when they went into closed session to authorize a settlement with the claimants, which was the victim's family in this case. And looked into that to get that information. They did authorize their city attorney to settle the claim for damages, which became the civil lawsuit. They didn't come back with the actual settlement documents, which could just be a quirk with LA City. Usually you do see those settlement documents filed or presented to the city council under the Brown Act. That didn't seem to be the case here, although it's possible I missed it in my review of those minutes. And then we also followed and found on the website of the attorneys that were representing the family, their announcement of the settlement as well. As for LAPD, it looks like they did a separate investigation of the complaint that was filed by the family of the victim, which is documented in the ISF.
Thank you.
You're
Yeah,
welcome.
and specifically on the federal court records, I reviewed the affidavit alleging the civil case, which was dropped in lieu of the settlement. So we had the full affidavit on that.
Commissioner Gordon, please.
And I just want to clarify, the LADA's office still has not made a determination on this case.
That is correct. The LADA's office, my last communications with them were in October of 2025. At that point, my understanding was that an independent oversight firm had completed their investigation and the investigation was still under review.
And I've spoken with them more recently. I spoke with them last month and they still had not made a charging decision.
Commissioner
Go ahead.
Dorr, in regards to that question, was there any discussion on holding this case before it comes to the commission until we have the review from the district attorney's office?
We did have a discussion. We felt based off of the time that had passed that we needed to bring this case. This incident obviously did occur back in December 2021. The DA's office and the DA's office is the criminal case is a totally separate incident than this one. These officers need to have closure. The public needs to have closure. The victim's family needs to have closure. And these separate incidences.
More questions? Commissioner Gordon.
I wouldn't call them completely separate incidences. And the evidence that comes from the DA's review, I think is extremely important to this body's ability to make a decision. Or even if this body were to send this to an ALJ, that's extremely important information. I think asking this body to make a decision based on this limited, what we have, you really put this body in a very challenging situation without that full evidentiary hearing. So I will say that, and before the officers and their attorney get up and present a case, I'm gonna make an unusual request. Could this either be stayed for waiting on that district attorney's investigation? Or in order to get the full evidentiary hearing without this body making a determination, could this go to an ALJ?
If I may, Commissioner Gordon, I misspoke. They're separate proceedings. I will point out that as these officers are still employed, anything that they say in an ALJ proceeding would be considered compelled statements. So just as those compelled statements would have been protected from the criminal proceedings, it could not be used in a criminal proceedings, they would not be able to be used against them in a criminal proceeding. So we could develop a full factual record in the ALJ proceedings so that you could make a determination on a fully developed factual record in this case. So they are entirely separate proceedings for that purposes, at least. We do not necessarily therefore need to wait for the DA to make their determination. The DA obviously has a lot of political considerations as to how they'd like to charge this case. They have a higher burden of proof of beyond a reasonable doubt versus ours of clear and convincing. That may be part of the reasons why they haven't decided to charge. Also, they're looking at this from an entirely different standard. They're looking at this as potentially, possibly, criminal conduct, whereas we're looking at this from a disciplinary standard. So I would respectfully disagree on that point as to whether or not we could possibly take this. But as I said, they would have the protection in the ALJ proceeding as they would be compelled statements.
I'm going to respectfully disagree on how valuable the DA's investigation would be to this body's ability to make a determination. But I'm going to ask Chris, could we, as a body, refer this to an ALJ for a full evidentiary hearing as a motion, as an action, versus trying for us to make a decision on whether we're going to recommend decertification? Because if we recommend decertification, correct me if I'm wrong, these officers will be placed in the position where they are taken out of the field. Why that? No? Okay, perfect. But could we, and I just want to know if this is an option. I'm not saying, clearly we haven't deliberated, we haven't had discussion, but I'm just asking the question if that is an option.
So just so that I understand the question, and before I answer, it sounds like you're looking at, can this body send it to an ALJ without a disciplinary recommendation?
Yes.
And yes, the answer is yes.
Thank you.
The questions at this point.
Obviously, I just want to clarify, I mean, there needs to be a motion and support and votes and, you know, all the other mechanics, but in
Yes.
theory, what we're talking about is a theoretical vote that had, or motion that had the supporting votes.
Yes. So I would just, I'll make the unusual request to, if there is an appetite from the rest of the commissioners actually to go to closed session at this point and discuss that, or to move forward with testimony from the attorney and the officers, so.
We can go to closed session anytime the commission would like. I would generally, we would hear from, first we would hear from the respondent. What is the will of the commission? I believe the respondent's attorney and the respondents are here. What is would someone like to go to deliberations now? Or would you
Commissioner
rather hear-
Doring.
Can we go chat for a few minutes?
Absolutely. Absolutely. All right. So we will briefly convene to the conference room and we will be back shortly. Chris, I should ask you, we've had this conversation. Where was my mic? We're back in session now. We thank everyone for their patience. Do the subject officers and or counsel wish to make public comment? I believe so. Okay, well, no, we'll take it. No, we'll go with you first no, we'll go with the attorneys and the officers first, then we'll do public comment. Yeah. Board, welcome. Welcome, Ms. Wills Cox, Mr. Zavala, Mr. Quintanilla. You each have 5 minutes to speak. Please complete your comments within this time. Before you begin, please remember the commission shall consider only the facts presented by the division today and will not consider additional facts or defenses at this time, including character witness. The sole question before the commission today is, do the facts offered by the division today, if proven at a later evidentiary hearing, demonstrate a high probability that serious misconduct as defined in the penal code and commission's reg occurred?
Yes, sir.
Okay, welcome.
Good morning. My name is Jose Zavala. I would like to thank you for the opportunity to speak here today. On December 18, 2021, I responded to a radio call for an ambulance attempt suicide for a subject who was armed with a large butcher knife. Before I arrived, I received additional information that the suspect was chasing people with this butcher knife, upgrading the call to an assault with a deadly weapon. And I mentally prepared myself to face a violent armed suspect. When I arrived, Mr. Lopez was sitting on the steps holding a large butcher knife and began cutting his throat. So I requested an ambulance to treat Mr. Lopez once he was taken into custody. My plan at the time was to arrest Mr. Lopez for assault with a deadly weapon and get him mentally evaluated. It was not a situation where I could tactically disengage and leave Mr. Lopez in public with the knife. I pleaded with Mr. Lopez multiple times to drop the knife, in English, in Spanish, which was his native language. I called him by the name his family called him, which is Junior, to appeal to his emotions and get him to listen. Mr. Lopez was struck by a 40mm less lethal round, which had no effect on him. And he immediately started advancing down the stairs towards us, then sat down at the bottom of the stairs. After efforts to get Mr. Lopez to drop that knife, he stood up aggressively, hitting his hat off his head and holding the knife above his shoulders. Mr. Lopez took another 4 steps, advancing towards officers, and turned to take another step toward me with no intention of stopping. I felt that Mr. Lopez was too close to me with that knife, that he could quickly close the distance. The 40mm less lethal round had already been ineffective on Mr. Lopez. As he continued to advance toward me, I reacted to Mr. Lopez's actions and his failure to comply. As a last resort, I defended my partners and myself. During my interview, immediately following the incident, I told investigators that Mr. Lopez was approximately 10 to 15 feet away. I made the decision to use deadly force based on how close the imminent threat was, not based on exact measurements, or how my body worn would be judged using 20/20 hindsight. The LAPD Use of Force Review Board found my shooting to be out of policy. While I respect their decision, I do not agree with it. The board did not support my belief of the imminent deadly threat, that my fear was predicated on the likelihood of future harm, not an imminent deadly threat. The definition of imminent is about to happen or likely to occur very soon. I was given 10 suspension days by my department, and I was removed from a specialized assignment that I worked hard for. Looking back, I wish I had appealed the disciplinary action, given the opportunity to explain myself. It would have been changed to in policy, and I wouldn't be here fighting for my post-certification for doing my job. I remained a police officer with the Los Angeles Police Department because my department did not feel that my actions were cause for termination. It was Mr. Lopez's violent actions that led to the use of lethal force. Not a day goes by that I do not think about Mr. Lopez, and I wish there was a different outcome. I had attended de-escalation training and had de-escalated numerous situations with armed suspects. I did not make the decision to use deadly force maliciously. I acted in good faith and tried my best to de-escalate the situation. I take great pride in protecting and serving the community that I grew up in. Throughout my 18-year career, I received over 200 commendations from the public and from within the department. In 2021, I was awarded Specialized Officer of the Year in Newton Gang Enforcement Detail. And in 2025, I received Officer of the Fourth Quarter. I'm always looking to improve myself. As an officer, through extensive training, I am humbly asking for a chance to keep my post certification and continue to do my job. Thank you.
Thank you, Mr. Zavala.
Good morning, everyone. My name is Julio Quintanilla. I also want to thank you for the opportunity to speak here today. Just like my partner stated on December 18, 2021, my partner and I wanted to help Mr. Lopez. We tried to de-escalate the situation, just like we are trained to do so. I'll speak about Mr. Lopez's actions briefly to show our mindset, train of thought. Mr. Lopez had been chasing citizens of our community with a butcher knife. Even his family members were in fear of Mr. Lopez and believed he was going to hurt them and hurt someone in the street because Mr. Lopez had already assaulted someone with a butcher knife. Our priority was still to take Mr. Lopez in custody without anybody getting hurt. Having reverence for human life has and will always be my #1 priority. Working in South Los Angeles, I've been in numerous incidents involving edge weapons where I've been successful in de-escalating the situation and having a positive outcome due to the individual's actions. Unfortunately, that wasn't the case with Mr. Lopez. Mr. Lopez's dangerous actions, holding the butcher knife above his shoulder, ignoring the multiple commands, advancing towards me and my partners, closing the distance, posed an imminent threat. Unfortunately, his actions forced me to use lethal force to stop him from causing serious bodily injury or death to myself, my partners that were around. After, less lethal force was ineffective. As many of you here may know, our job is very demanding and dangerous. We respond to these type of radio calls with the intent to help and protect our communities, and sometimes we must make split-second decisions. These decisions don't always result in a positive outcome due to the individual's actions. Due to this incident, the Administrative Review Board process took a psychological toll on me. I was removed from a coveted assignment that I worked hard for and was later isolated from the public, my peers, and some family members for almost a year. However, I continue to believe wearing the badge, helping the community, is a privilege that I do not take lightly. After completing my restrictions and going through extensive training, I was allowed to continue serving my community where I was raised. Since this incident, I promoted to field training officer, a position where I have the privilege to teach and mentor newly hired police officers in California post and department policies and tactics, and training for different incidents they may encounter. I was also humbly awarded the Jose Arellanos Excellence and Training Award for Field Training Officer of the Year 2025. I'm currently now part of the Vice Specialized Unit, where I work closely by the Homeland Security, FBI, ABC agents, and other agencies to investigate human trafficking, prostitution, and illegal gambling cases in an undercover capacity. This is a position of high trust given to officers that are dependable, experienced, and in high integrity. Again, there was no malice in my heart. Becoming a police officer was always my lifetime ambition. I became a police officer to serve and protect the public, to be a person my community looks towards in the darkest times. I entered this profession for the right reasons. I still see this as a profession and not just a job. I know that great responsibility it is to be a father and a police officer. I think about Mr. Lopez every day, and I only wish we could have found a way to have Mr. Lopez drop the knife. That way we could have helped him in whatever he was going through. That day, Mr. Lopez had the ability, opportunity, and the intent to cause serious bodily injury to somebody. I only did what was necessary to do to protect our community, my partner, and myself. To close, I ask to please put yourself in our shoes. I know many of you have been in critical situations and know how difficult this job can be. I ask that you look at this incident from the perspective of a father, a son, a brother, a Christian man that only wants to be the best he can. Thank you for your time and understanding.
Thank you, sir.
Yes, sir.
Ms. Wilcox?
Good morning, everyone. I just wanted to touch on a few points with the investigative summary and then the advisory board. Barnes versus Felix is a new U.S. Supreme Court case that came up in the advisory board, and I think it's really appropriate for this particular situation. I know you are all very familiar with Graham versus Connor, but Barnes versus Felix specifically mentioned that the totality of the circumstances in a situation where an officer is making a decision has no specific time limit. That earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later facts and circumstances, and that prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening instead of innocuous. And to me, that feels very appropriate for what Officer Zavala and Officer Quintanilla said in the LAPD report that you have in their statements, that the act of him making the sign of the cross, knocking off his hat, turning to face them, raising the arm with the knife in it, making eye contact, and taking the steps toward them with the totality of the circumstances that they had prior to that, with him chasing other people with the butcher knife, the ineffectiveness of the less lethal rounds, and his apparent threat to the community coming closer to them with making those same objective motions and intent, which was what they perceived, that plays a large role in whether or not their actions were reasonable under the law. They also gave specific examples of why they felt it was imminent, and then therefore their use of force was necessary. I'll remind you that they were the designated cover officer, which is a lethal force position for LAPD. There was another designated cover officer, Officer Meraz, M-E-R-A-Z, which is also in the LAPD report, the FID investigation. He also specifically said that he was going to shoot at Mr. Lopez, but he did not because he was not the designated cover officer on that side. Officer Zavala and Officer Quintanilla were. So according to their training and experience, that Officer Meraz should have waited, which he did, and allowed the designated cover officers closer to make that decision. My point in bringing that up is that the standard is whether or not a reasonable officer in a similar situation would have perceived the same imminent threat. And in this case, you have another LAPD officer similarly trained with similar experience that perceived that same threat at that same moment. The officers had already described, which I'm sure you read in the FID report, what they perceived, so I won't go through that again. I don't believe that these facts will allow the presentation of evidence, if it gets to an ALJ, to meet a clear and convincing standard. It is a high probability. It is just below, beyond a reasonable doubt. What I'm actually asking is that you take no action at all on their certification. But if the board chooses to, I'm asking that it be suspension instead of revocation. I would note that the division recommended either suspension or revocation, both to the advisory board and again to you today. So I do think that that says something about the level of the perceived misconduct. I'd also note the expert that was retained by the division is not an LAPD officer and not similarly trained. One of the things that I thought was interesting is that he felt that the victim, Mr. Lopez, only presented a threat to himself, and that the officers didn't have any business using lethal force when he didn't present a threat to anyone else. And I just would like to point out for this commission that Mr. Lopez did, in fact, he did present a threat to himself also. But at the times that he was physically harming himself, The officers did not fire at him at that moment. So the fact that he was cutting his throat or cutting his hand was not cause for Officer Zavala or Officer Quintanilla to feel that they needed to intervene with lethal force. It was only when he turned and presented an imminent deadly threat to both the officers and other civilians at scene that the officers felt that they needed to use lethal force to stop that threat. A minor point is that the weapon keeps being referred to sort of as a kitchen knife or just a knife. And it is noted within the investigation that the first officer on scene described it as a big butcher type meat cleaver. The FID report called it a knife that looked like a meat cleaver and then described its size. The blade was over 6.5 inches long, not counting the handle. So I don't think that downplaying and the size of the weapon or the perception of the officers at scene does anyone any good in trying to determine what the perception of the officers was at the time. Again, the totality of the circumstances, which that latest case specifically includes, but it is also included in your regular analysis of the prior information that Mr. Lopez had been chasing citizens with that same butcher knife. That the intent of the officers was to arrest him for an assault with a deadly weapon with that butcher knife, as opposed to just being a danger only to himself. The sergeant on scene, if you refer to the FID report as well, it's page 8, 9, and 10, basically. He talks about what a danger he believes that Mr. Lopez was both to the community and to the officers throughout the encounter, how they had no ability to disengage from that threat. And that he also similarly interpreted Mr. Lopez's sign of the cross as basically a decision line that he was making, that he had made some sort of decision at that point. And that he was either going to take off running with that butcher knife and attack the citizens that were nearby, or he was going to take off running towards the officers. That was the sergeant's perception as well. And that's why I believe that you'll have a very difficult time proving it beyond clear and convincing, because you do have multiple similarly situated and similarly trained officers who had the same reasonable perception that Officer Zavala and Officer Quintanilla did. Thank you.
Thank you, Ms. Wilcox. Any questions or comments from commissioners? Seeing none. Thank you very much, Ms. Wilcox. Thank you, officers.
Thank you.
Thank you.
Is there anyone else present who would like to address the commission regarding this case at this time? Please come forward, sir. You may state your name and organization if you wish. You will have 1 minute to speak. Please complete your comments within this time. As requested of counsel for the respondents, I ask that you please address your comments to the presented facts of the case, not to new facts, new defenses, or character witness. The floor is yours, sir.
I only have a minute, sir. Good morning. My name is Saul De Leon. I am a law enforcement sergeant, and I've been with the LAPD for over 2 decades. I personally know Zavala and Quintanilla for over 1 decade. I wanted to speak to a couple things. I'm limited, so I'll try to rush it. I wanted to be some type of character witness, just illuminate that the fact that they're leaders with the LAPD, with the Newton Division. They work very, very hard, and they lead from the front, always there. And they were designated cover officers on that day for that specific reason, because they're dependable, they're counted upon, and they can make that decision to make sure everybody goes home at the end of the day. Another thing I wanted to talk about is the complaint history. Commissioner Nieto mentioned it. With the LAPD, we take numerous complaints, no matter what it is. And we have tactics that we use in briefs and ways we deal with the criminal element, and they also have it as well. They generate numerous complaints to try to deter officers from continuing to work, being productive in certain areas, but that has never stopped them. Even though they've got numerous complaints, that has never stopped them from continuing to patrol and be the product the community needs. I believe that decertifying them would take two very good officers off the streets. Two officers that I have seen grow and become professionals and learn from this incident and teach officers about this incident. These officers are commendable, and I wish we had more officers like them on the street. So that's all I wanted to say, sir.
Thank you for coming, sir. Thank you. Is there anyone else who's present who'd like to speak? Please come forward. Same admonition, please, that you'll have 1 minute to speak and try to speak as we ask of the attorney and the respondents, keep within the facts and avoid new defenses or character witness. Thank you.
Good morning. Thank you for allowing me the opportunity to speak. My name is Serena Zavala. I'm a detective employed by the Los Angeles Police Department and the wife of Officer Jose Zavala. As a police officer, I have learned not to judge other officers' actions by watching their body-worn video. The situations officers encounter, the feelings and the threats are very real. I have worked with both officers, Zavala and Quintanilla, on patrol at Newton Division, and they're both very hardworking officers with great hearts. They did their job dealing with a dangerous and violent man who refused to listen to commands and continued to advance towards them with the large butcher knife. They were forced to make a decision to defend themselves, and any reasonable officer, including myself, would have defended themselves in that situation. As his wife, I have seen the emotional and physical toll that this incident has taken on my husband. At the time of this incident, I was 5 months pregnant with our first son. He went to work every day, putting his life on the line for others with his future son in mind. He was faced with an impossible decision to defend himself, and I thank God every day that he's here for our two boys. My husband is patient. We have 2 toddlers, and I've never seen him lose his temper with them, even after a hard shift. He is honest, optimistic, and has strong morals. I'm so proud of the officer that he is. Everyone who works in his vicinity is impacted by his leadership, his motivation, and his optimism. I see the work that he does on himself every day to be a great officer, husband, and father. While making your decision today, please take into consideration that a man armed with a butcher knife does not need to be inches from you to pose a threat to your life. And that 3 rounds fired in under 1 second is not excessive or unreasonable to stop a threat. Watching a video from the safety of this room does not show the totality of the circumstances. Officer Jose Zavala should not be judged solely by one moment in his career, but by his service to his community, his commitment to this profession, and the person he has been throughout his career. Thank you.
Thank you, Ms. Zavala. Is there anyone else present who would like to address the commission at this point? Welcome, please come forward. Same admonitions apply. You have 1 minute, and please try to address the facts of the case. Thank you, welcome.
Thank you. Good morning, everybody. My name is Joanna Martinez. I'm a Los Angeles police officer, and I've been on the job for 10 years. I stand here before you all to give you insight of my friend Julio Quintanilla. I have known him for 10 years because we met in the academy together. We were classmates. He's a great husband, and he's a father of 2. Julio is somebody I look up to for his compassion, his work ethic, and his character. He has been dedicated to his career, to integrity and commitment to public safety. I have witnessed his willingness to help others without recognition. During my time in the academy, I struggled, and he was the only one who motivated me. He was the only one who pushed me to continue to succeed. I will forever be grateful for his kindness and his care for others. I now have the honor to work with him directly as a partner, and I continue to witness his motivation. On Saturday, April 25th, he sent us a text message saying, "Stay coachable,
through all phases of life, never stop learning and listening. He is that type of officer who stays motivated and continues to do his job regardless of what he is going through in life and with his family. Respectfully, I ask you that you carefully reconsider this decertification because he's a really great officer and I would hate to lose him as a partner. Thank you.
Thank you, Ms. Martinez. Thank you for coming. Is there anyone else present? Come forward, sir.
Hello, good morning, and thank you. Alejandro Puche, I'm a police officer with Los Angeles Police Department. I've been employed for 18 years with them. I know we're short on time, but just some things to consider. Like Chief Nieto said, with a lot of complaints that come, I think one of the things that should be looked into is a lot of complaints come because of result of an arrest. Should that be a factor in making a decision on whether an officer is good or bad? No, it shouldn't, because no one likes to go to jail. That's something that should be considered. Another thing, the time the call came out, from the time the call came out to when officers got there was 13 minutes. That's 13 minutes that that the victim had to like calm himself down or whatever. That in itself is a form of de-escalation. Once officers got there, and they made contact and they had their de-escalation, there was the initial 40mm round that was shot. From there was another 7 minutes of de-escalation that continued on. So with them having that, they knew, the 40mm round wasn't working. And then when the second 40mm then were shot, when the victim was shot, that's when that decision was made. Last thing is, when it comes to these officers and their careers, I believe that all the facts should be, represented before decision made, before decertification. Thank you.
Thank you. Is there anyone else present who would like to address the commission at this time? Seeing none? After a long closed session, I'll entertain a motion. A motion is always in order, or what is the will of the commission?
Commissioner Terrio. I'll make a motion to refer the matter back to post with specific intent to review and bring back to the commission further evidence, including 911 logs, the full videos, the full body camera videos, any other videos that were obtained in any LAPD investigation or the division's investigation, and the DA's report when it is concluded.
Is there a second?
Doring seconds.
There's a second. Mr. Knapp, would you please call the roll?
Yes, Mr. Chair. Barcelona,
Yes.
Braun,
No.
Brazil,
No.
Cooper,
No.
Doring,
Yes.
Duggan,
Yes.
Gordon,
No.
Johnson,
Yes.
Long,
No.
Moodian,
Yes.
Moon,
No.
Nieto, Rodriguez,
No.
Terrio,
Yes.
Woolry.
No.
6 yeses. 8 noes.
Motion fails.
Abstention.
Commissioner Gordon.
I'd like to make a motion, please. I'd like to refer this matter to an ALJ full evidentiary hearing with no discipline recommendation from the commission. Second.
Mr. Knapp, please call the roll.
Barcelona,
No.
Braun,
Yes.
Brazil,
Yes.
Cooper,
Yes.
Doring,
No.
Duggan,
No.
Gordon,
Yes.
Johnson,
No.
Long,
Yes.
Mudian,
Yes.
Moon,
Yes.
Nieto, Rodriguez,
Yes.
Terrio,
No.
and Woolry.
Yes.
10 in favor.
Motion passes. All right, we'll now take a 5-minute break between cases. We can resume. We've still got two cases to deliberate. Thank you very much. Our next case is 2507337, Matt White. The board voted to revoke certification 4-0. Post Law Enforcement Consultant Richard Collins and Bryant Henley, Post Legal Affairs Bureau, will present. Gentlemen.
Good morning, Commissioners. My name is Rick Collins. I'm a law enforcement consultant assigned to the Professional Conduct Northern Bureau and the Peace Officer Standards Accountability Division.
Oh, excuse me. I'm going to recuse myself from this case. The officers with my department, I was involved in the investigation, so I'm going to recuse myself and step away from the dais.
And I just have a follow-up. The chair said that the advisory board voted to revoke. I thought the advisory board voted to suspend. I just want that to be clear before we start.
Yeah, thank you, Commission Member Gordon. That is correct. The board made a recommendation of a 3 months suspension stayed, subject to terms and conditions that post staff would determine. That was the general gist of it.
Okay, I'll start again. My name is Rick Collins. I'm a law enforcement consultant with the Professional Conduct Northern Bureau and the Peace Officer Standards Accountability Division. With me today is Bryant Henley, an attorney with our Legal Affairs Bureau. I'm here today to present case number post 250-7737 involving Deputy Matt White, who at the time of the incidents was and still is employed by the Sacramento County Sheriff's Office. The division found clear and convincing evidence and reasonable grounds to believe that Deputy White engaged in serious misconduct in violation of California Penal Code Section 13510.8 B6 based upon 2 driving under the influence convictions. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 13510.85A4, the POSAB heard this case on April 15th, 2026. Following the conclusion of the hearing, a majority of the board voted to recommend a 3-month suspension of Deputy White's certifications and to stay the suspension under certain conditions. The division now presents this matter to you for consideration of suspension or revocation. As required by Penal Code Section 13510.85A5, the record of that proceeding is before you today, including the agenda and attachments from that meeting, a transcript of the relevant portions of the hearing, and the recommendation of the board. The board also adjourned into closed session before voting on this matter, and a commission counsel will be able to advise you with respect to those proceedings. The law requires your review to be of the record before the board, which the division provided to you and which you've had the opportunity to review. To assist you in your review of the record, I will take you through the case as presented there. As presented to the board, the clear and convincing evidence substantiated that Deputy White violated California Penal Code Section 13510.8 B6. Deputy White was convicted twice for driving under the influence. These acts are sufficiently egregious or repeated as to be inconsistent with a peace officer's obligation to uphold the law or respect the rights of members of the public. Deputy White began his career with the Sacramento County Sheriff's Office on September 5th, 2004. He holds the following post certifications: basic, intermediate, and advanced. Deputy White had 3 complaints during his career dating back to 2016. One was for discourteous treatment, which resulted in an exonerated finding. The other 2 were for conduct unbecoming an officer related to his 2016 and 2024 DUI arrests. According to the Sacramento Sheriff's Administrative Report number 2016 PSB Paul Samboy -158 associated with the 2016 incident. Deputy White received a 160-hour suspension without pay, of which 80 hours were held in abeyance for 1 year. The Sacramento Sheriff's Administrative Investigation Report number 2024 PSB -0421 associated with the 2024 incident stated Deputy White received 160-hour suspension without pay and was reassigned to a non-driving assignment in the jail facilities. On August 4th, 2024, Deputy White was arrested by a Folsom police officer for violating California Vehicle Code Sections 23152A, driving under the influence, and 23152B, blood alcohol content of 0.08% or greater. Deputy White's BAC measured 0.11% by volume. On June 11, 2025, he was convicted of California Vehicle Code Section 23152B, driving under the influence with a BAC of 0.08 or greater. Sergeant Yates was assigned to conduct an administrative investigation into Deputy White's DUI arrests. The investigation was submitted to post after its completion. During his administrative interview, Deputy White told investigators he thought he was okay to drive the night of his arrest. He said he fell short and made a mistake by having his last drink before leaving the bar. He admitted there was no reason for him to be driving that night and that his actions were not in line with the department policy or the department's vision, mission, or values. He said his actions brought discredit to the organization. Additionally, he told investigators he resumed attending Alcoholics Anonymous meetings in conjunction with completing an alcohol treatment program in Southern California. Post-Professional Conduct Northern Bureau interviewed Deputy White on December 18th, 2025. The interview took place at Post Headquarters. Deputy White's attorney, Joseph Hoffman, was present for the interview in its entirety. The following is a summary of the interview and not a verbatim response to every question that was asked. Deputy White maintains he has not had a drink of alcohol since January 12th, 2025. His efforts to stay sober are supported by weekly meetings with a counselor through an alcohol treatment program. Additionally, he attends Alcoholic Anonymous meetings once a week. His efforts are also supported by meeting with a counselor from the mandated 18-month DUI completion program, which he anticipates completing in February 2027. During the aftermath of his second arrest, Deputy White met with fellow employees who offered their support and guidance. At the time of his interview with Post, he did not maintain a log that documented his meetings with various counselors. At the time of his arrest in August 2024, Deputy White's driver's license status was valid without restrictions. Before his arrest, he worked at the North Patrol Sector as a field training officer. He is currently assigned to the Rio Consumnes Correctional Facility. Although his driver's license is currently restricted, he could drive a county vehicle if the current administration were to sign a form acknowledging that Deputy White is required to use an ignition interlock device in his personal vehicle. If the administration signed the form, Deputy White could drive a county vehicle if it became necessary. On April 16th, 2016, California Highway Patrol Officer Furman arrested Deputy White for violating California Vehicle Code Sections 23152A, driving under the influence, and 23152B, blood alcohol content of 0.08% or greater. His BAC measured 0.12% by volume. On July 16th, 2016, Deputy White pled no contest to misdemeanor violation of Vehicle Code Section 23152A. He was sentenced to 3 years informal probation and 48 hours of sheriff's work project. At the time of his 2016 arrest, he was employed as a deputy sheriff. The Sacramento County Sheriff's Office initiated an administrative investigation into Deputy White's 2016 DUI arrests. Sergeant Marcus Gregory conducted the administrative investigation that was later submitted to Post. During his interview, Deputy White told investigators he was aware that alcohol was a little bit of a problem in his life. He said he was introduced to Alcoholics Anonymous in September of 2015, where he attended meetings off and on. He continued by saying he had been sober for 45 days prior to his arrest in April 2016. Since that arrest, he went back to AA, found a sponsor, and abstained from alcohol since the arrest. He also expressed the feeling of embarrassment he had for himself. Following the board's questions, Vice Chair Doyle gave Deputy White and his attorney 5 minutes to speak, as documented in the transcripts before you. As it is reflected in the video recording and transcript of the board proceedings, 2 members of the community also addressed the board and provided public comments. The board then went into closed session. When the board returned from closed session, it voted to impose a 3-month suspension of Deputy White's certification. With the suspension stayed, subject to certain terms and conditions determined by post staff. 4 members voted in favor, 1 voted against, and 1 abstained from the vote. At this time, I'm happy to answer any questions from the commission.
Questions from commissioners? Seeing none at this time. Thank you, gentlemen. Does the subject officer and/or counsel wish to comment? Welcome, come forward, please. We'll each have 5 minutes to speak. Please try to complete your comments within this time. Remember, the commission will consider only facts presented by the division today, not additional facts or defenses at this time, including character witness. Gentlemen.
Thank you for your time. My name is Joe Hoffman. I represent Matt White. I have some very brief comments about the mitigating circumstances in this case, which are relevant to your decision. And then you're going to hear from Matt White. A couple things to note. There was a fairly significant period of time in between these 2 DUIs. Neither case involved aggravating circumstances in the sense of there was no high blood alcohol level in either case. There was no excessive speeds. He was not armed at the time. Throughout both investigations, he was cooperative. He was respectful. However, Matt White recognizes that driving under the influence is dangerous. I think people who have problems with alcohol, it's a process in learning that some people can't drink. Matt has figured that out and has taken proactive steps to ensure that he doesn't drink and this never happens again. He's going to talk about his 45-day residential treatment, his evolution through that process, and describe how he did not have the appropriate support he needed back in 2016. Matt has already suffered some significant punishment as I've helped him navigate the DMV process, the administrative discipline process, the jail sentence. His department suspended him for 160 hours. 80 of that was stayed. The criminal court sentenced him to 14 days in jail. However, they allowed him to do some alternative sentencing. And as you heard, he is weekly participating in the 18-month DUI program, as well as attended counseling and is in AA. I will note that Matt has no prior discipline with Post. He's been a police officer for 22 years, and his entire disciplinary record is before you. It's the problem's alcohol. There are 2 DUIs separated in time. But again, police officers are regular folks with real problems. And when you hear from Matt, I think it'll be obvious that he's taken responsibility for his problem with alcohol, taken proactive and significant steps to ensure that it never happens again. And has remained alcohol-free for approximately a year and a half. I will note that the board's recommendation for a 3-month suspension and it be stayed with sobriety-related terms I believe is consistent with the post-disciplinary guideline rules in pages 21 through 27. And when it comes to conditions of probation, should you recommend it or adopt that decision, I would note that he has completed significant therapy, completed a very comprehensive 45-day residential treatment designed for first responders. And I'd ask that that be deemed satisfied. Ultimately, Matt is asking for a probationary term. He is certainly taken significant steps to ensure this never happens again. I believe the recommendation by the board accounts for the fact that police officers are real people with real problems, and they, having heard from Matt, believed him that this would not happen again. We'd ask that Matt's vocation, his calling, his career as a police officer not be deemed as disposable. We ask that you give him an opportunity to continue to redeem himself. Thank you.
Thank you.
Thank you, and a good morning. Good morning to you guys, and also good morning to Investigator Rick Collins. Rick Collins has been nothing but professional and courteous and kind to me throughout this whole process. You guys have a great investigator with him. I want to point that out. And we're here today because of me. There is no other excuses. There's no other implements of anything. I accept what I have done. And from the first time I got pulled over till now, I've wanted to redeem myself. I apologize to that officer for putting him in that situation. And the craziest thing that you're going to hear today is that August 4th, 2025 was the best thing that ever could happen to me. Since then, I have addressed the alcohol-related symptoms of my personal life. I sat there and I was very humbled by the situation, and I looked at other programs, DUI outpatients, and they all offered DUI counseling and everything, but I wanted something deeper. And around the first of the year, I found a First Responders of Wellness class down in Newport, California. And in the midst of stress and knowing where my career is, I put myself in there by no obligation to everyone else. If I had lost my job, I wanted to be sober for my family. And I put myself at a time when our son was brand new and born, and I spent 45 days there. And the reason I chose that was because they had therapy, and they also had proactive PTSD, things from neuroscience to studies. It was an intense 45-day program of counseling. And I think the question that everyone wants to know is, what's the difference in going forward? And I humbly tell you, I got therapy. And since then, I have treated that 45 days, but every week for almost a year and some change now, I've met with that same therapist over Zoom for an hour every week. And I've continued to go to my AA meetings every week. I've continued to go to my DUI programs. And I don't say this to post this, or it's because I had a problem. And I recognize that I want to be a part of a solution. As I look at some of these young guys being in 22 years now, what a challenge they have. What a challenge that they have with alcohol. And I want to be a part of a solution. I want to be able to address what I've done and what has worked to this next generation, because they have worse problems than I did. And I really, heart goes out to them. And I hope it speaks to the character of the depth of my sincerity. When all this was done and all the proposed discipline was done, I really made a point to seek out our undersheriff, Mike Ziegler, not to say, where do I go from here, but to apologize. Because I love the Sacramento County Sheriff's Department. And I'm so difficult to this day that I brought shame to my profession, my career, but to my Sheriff's Department. They've given me everything I've ever had in this life, and they deserve better. And they've given me integrity. So when I met with Undersheriff Mike Ziegler, I simply wanted to say sorry. And he accepted that. And he said, now it's time to go out and be a success story. And to do that was in line with going back to the jail and teaching these younger guys the pitfalls of alcohol. And as I go on in my life, that is exactly where I'm led to now. And I simply want to say that I got therapy and I feel better, and that I accept the responsibilities that I've done. And I humbly say I didn't have a cop problem, I had a drinking problem. And I've done everything humanly possible to correct that now where I can be a better cop. Thank you for your time.
Thank you, Mr. White. Any questions or comments from the commissioners? Oh,
Commissioner
Mr.
Terry.
Moody, Commissioner Moody.
Go ahead.
Go ahead,
Yes, sir.
Commissioner Moody.
Officer, I appreciate your testimony today, and I also respect that you're holding yourself accountable.
Yes, sir.
For these actions. And it's very good that you're in therapy and that you're also in AA. It's very commendable that you're doing that. I am concerned about 2 DUIs. And the question that I have is, what assurances can you provide the public and this commission that there won't be a third?
Yeah, I think the biggest thing, the first thing that comes to my mind is that I've had therapy, that I addressed the issues of why I was drinking, but also that comes with action and comes with deliberate action. My wife and I have been sober now. There's no alcohol in the house. There's we don't go to parties. We have committed to, we have 2 young children, and that alcohol will not be related to any of my problems. And I think meeting with a therapist every week and AA counselors and meetings has addressed that.
And we've read what you've submitted. What measures did you take after the 2016 DUI, and why weren't they successful?
I appreciate you asking that, because that was a 2016, that was 8 years ago. And I think there was, unfortunately, this was no excuse, but there was still a culture in law enforcement that there was a acceptability of that. And I completely condone that now. And I didn't get therapy. I went to AA, and AA kind of rubbed me wrong a little bit different. And I also, but since then, have gotten married and gotten matured. And also, to circle around, I got therapy. I really did.
Thank you.
Thank you.
Mr. Terrio, did you have?
Mr. Terry, I really appreciate your comments.
Pleasure.
I appreciate your commitment, and I really think it makes a big difference in the fact that you're willing to come forward and state that. I think that's still a issue in our profession. So I really appreciate your comments and your commitment to what you're going to do. Opposed to, not the kind of continued like passing the buck of like, oh, well, this happened because of that, and you're owning it. And I think that says a lot about your characters. Thank you.
Well, thank you, and I appreciate it. I hope that answers the previous question, that my character has been reinforced, and who I am, and hope what I continue to do.
Commissioner Doring? I also just wanted to commend you on your forthcoming and your honesty here with us today, specifically though with First Responder Wellness. I'm very familiar with their organization and have toured their facility, and I know that it's not an easy decision to go inpatient. I also know the level of therapy and care that they offer over AA. I know that's not easy, and I appreciate you taking those steps to complete that.
Well, thank you. There's one other thing I'll add to that about the FRW, the First Responders Wellness. They actually have a 94% success rate of officers and first responders going back to law enforcement and their careers. I think that speaks volume for what they're doing and the water they're treading, and thank goodness for them.
Mr. Nieto.
I just want to echo what some of my colleagues have said, and wish you the best in your sobriety and your recovery. But can you talk a little more about the difference on your first DUI? It doesn't seem like you talk about therapy, but you did the in-residence program at First Responders. And I know it's just not for alcohol. Their processes are a lot different. We've gotten better. of trying to treat these issues with their officers.
Yeah.
Can you talk about really why that will make a difference? That won't lead to a third one?
Yeah, I think I hopefully to answer your question, to clarify, I didn't get therapy after the first one. All I did was attempt to put a Band-Aid over AA. And also at the same time, I was trying to attempt to excel in my career, in my personal life, and my ego was still attached to there. And I think I did not put my alcoholism or recognize that to be at the first forethought of everything that I did. And having 2 DUIs and the embarrassment that came into the profession of my family and myself, you better believe it's my first thing I do every day. So now I do take AA serious. I do meet with, again, this has been over a year and a half that I every week meet with a therapist, and I go to my DUI classes. I go to AA. I believe I'm reinforcing everything, and I can to first address myself. I'm going to be a 60-year-old man, whether I'm employed or not. And how do I live with myself? And how do I look at my family? And that is my first objective of what I'm doing. And secondly, comes a career that I'm very proud of, but also sustains. So I hope that shows my commitment to sobriety.
Mr. Chair, can you read the recommendation from the advisory committee one more time? Or the post-council?
It was a 4-month, it was 4-0, I believe, for a suspension with 3 months stayed. And the specificity for probation was rather hazy, I believe, at the time. So I'm not sure where, I think they kind of defaulted to the commission in terms of the specificity of the suspension.
Mr. Chair, if it would help, I can read from the transcript the actual motion that ultimately passed. And it was from Vice Chair Doyle, and it reads as follows, quote, "I propose a 3-month suspension stayed, provided Deputy Matt White agrees to participate." It says participant. I'm going to read that as participate in a probation program determined by post staff. That is the motion that passed.
I have a motion, Mr. Chair.
Motion is always in order.
A motion to adopt the advisory's recommendation. With that, I think there is an agreement that Mr. Beatty has done in the past. So with the motion is to work out an agreement based on the terms and conditions.
Actually, the division that
Okay.
crafts the agreement, and then it comes back in form for adoption.
Yeah, and I'd like to second that motion because even though that's what Mr. Doyle stated, they were talking about what the commission has done in the past with these cases, so.
Yeah, I think the minutes clearly represent their interest in having the commission firm up with what we've done in the past. I would like to, we've got a motion in a second. I would like to hold that in advance for just a minute for public comment. If there's someone who traveled here, who came here, you've heard we have a motion at this time. Is there anyone here from the public who would wish to make comment at this time while we hold off on the vote for just a moment? Please come forward. A motion is always in order. However, we would like to recognize people who may have traveled to comment.
Good afternoon, Commission and Chair members. My name is Morgan White. I am Matt White's wife and the mother of our 2 young children. I want to speak to the likelihood of him not reoffending and reiterate the work that Matt has done on himself. How proud I am of him and the impact this DUI has had on our family for the better. I know that sounds absurd, but truly, the accountability that he has taken over the last 2 years since this incident is incredible. His sobriety alone has made him a new man and has led to my sobriety and our sober household. Realizing that raising our family and showing our children that sobriety is a much better lifestyle. Has made changes to his life, my life, when Matt went to rehab on his own decision, paid for with our savings. He was away from myself while I was pregnant with our newborn over there and our 2-year-old son at the time for 6 weeks. It was very good for him. It was a huge step for him to take, not only for himself, but for our family and for his career. I want to emphasize that all the steps that Matt has taken after his DUI were first for himself, second for our family, and third for his career. I'm sorry. He is very proud to be a Sacramento Sheriff's Deputy, and I ask that you consider the effort and the changes in his life, the accountability that he has taken. When you make your decision, we sincerely appreciate all the work that you have done in this case for us, for him, and we ask that you consider everything in totality. Thank you very much.
Thank you, Ms. White. Back to the motion, I would just for some clarity, we've got a motion, we have a second, but just for clarity, I'd like to ask Commission Counsel to address some of what the suspension entails, so we have a little bit more detail for the record.
Thank you,
It's
Mr. Chair.
General precedent by the commission.
Absolutely. And so on behalf of the division, if Mr. Chair, you're referring to the division's counsel, I'll describe this body in March adopted the guidelines, the disciplinary guidelines. Those included a list that you adopted of standard terms and conditions of probation as well as optional ones. So I will just try to summarize. Suffice it to say, similar to the other cases that this commission has heard regarding scenarios where there have been more than one DUI, those terms and conditions are described in the guidelines you adopted. Those are, in essence, terms number 4 through 15. Those are the standard terms and conditions. I'm happy to read those if that's a helpful thing to do. In addition to that, there are a number of so-called optional terms that this body adopted. Those optional terms are potentially among the terms this body may wish to choose again, or if this body wants the division to go back and look at prior cases and essentially try to emulate what those prior cases have been, that's another option. So either, I guess to summarize, this body, this commission could either select specific terms and conditions from the standard and the optional ones. I'm happy to read through those if that's helpful. Alternatively, this commission could direct the division to look at prior cases involving DUIs and adopt and take these guidelines that this commission adopted and attempt to essentially select those items that are consistent with what prior DUI cases and the outcomes that were held there. So maybe I'll pause and see what's most helpful.
Yeah. As the maker of the motion, Commissioner Johnson, as the maker of the motion, given what Mr. Henley has said, are you comfortable with which process would you like to add to your motion? That
Based on the prior agreements we've had with other respondents.
Yep.
Very good.
Right. Then we have it.
My second stands.
Second stand. So any other comments or questions before we go to vote, Mr. Moodian?
I'm sorry. So the motion is for the advisory board recommendation?
Yes, so it'd be the 3-month stayed, and it would be, and if you'd like, it's no problem. Mr. Henley can read the stipulations, and it's not a problem.
Would you mind doing that one more time?
Absolutely.
Mr. Chair, that might be helpful. I
Yeah.
believe we have 2-3 members that have not been through
And
this
a room full of-
probationary process.
A good idea.
Absolutely, yeah. Happy to do so. Again, I'm reading from the disciplinary guidelines that the commission adopted in March. And these are the so-called standard terms, and I'm gonna not read the entire paragraphs. I'll give you the headers, which I think hopefully gives the point. So it would be paragraph 4, which is a severability clause. That's essentially a clause that says if a court finds one piece of an agreement void, other parts of the agreement are enforceable. So there's a severability clause. That's paragraph 4. Paragraph 5 is obey all laws, which means what it says. The probationary person agrees to obey all laws during the term of probation, and it would be a violation not to obey them. Number 6 is to submit quarterly reports to the commission, whether there has been compliance with the terms of probation. So that's paragraph 6. Paragraph 7 says that serious misconduct may not occur. So if an individual engages in serious misconduct, that would be a violation. Paragraph 8 says interview with the commission, meaning that within 30 days of the decision, that the probationary person will appear and provide an interview with the probation monitors to determine how the probation will be monitored and handled. Paragraph 9 regards personal appearances. Upon reasonable notice by the commission that the probationary person will make a personal appearance when the commission directs that person to do so. Paragraph 10, cooperation with commission staff, meaning that the probationary person will cooperate with any directions post staff have in completing the terms of probation. 11, regarding change of employment or address, essentially the probationary person must report their address and keep that current. Number 12, notice to employers that any future or current employer must be notified of the outcome of these proceedings in the probationary terms. Paragraph 13 is to comply with the terms of probation, essentially meaning you must fully comply with all of the terms set forth that would be put in a written agreement, in a written order from this body. Paragraph 14 is that the continuance of the probationary term and completion essentially describes that if there's been a violation of the terms of probation, this commission body retains jurisdiction. So say you're on the last day of a probationary term and there's a violation, at that moment, it freezes the probation, allowing the commission to retain jurisdiction to take action. And number 15 is certification surrender, which essentially says what the law says, which is that a licensee may surrender their certificate at any time. So those are what are known as the standard terms and conditions. If so inclined, I can now describe some of the optional terms that I think this body may be interested in, if that's appropriate.
Sure.
Okay, and so with regard to the optional terms, there is paragraph 17 that this body adopted that has to do with criminal probation reports. That has to do, that's essentially a term that says if there is any criminal probation term, such as in a DUI, where there's a term of probation and certain conditions that must be completed, that those terms are also, in a sense, part of the terms of probation this commission is issuing, so that if there's a violation of the criminal terms of probation, they are also in turn a violation of this body's terms of probation. So that's paragraph 17, if this body is wanting to select that one. Paragraph 20 says that alcohol or drug counseling within 30 days of the effective date of the decision, that there must be attendance and participation in particular alcohol drug rehabilitation program. That's something this body could select or not. Paragraph 21 is proof of completion, that the probationary person must provide proof of completion and participation in any treatment that this body orders. Paragraph 22 is to submit to drug or alcohol testing. That's a common term we've seen in other cases. Paragraph 23 is to abstain from controlled substances, so alcohol and or other controlled substances. Paragraph 24 is specifically abstaining from alcohol use. And those are some of the optional terms and conditions among others, but those seemed most relevant here for this body to consider.
Questions? Again, Mr. Johnson is the maker, Commissioner Johnson is the maker of the motion. Any comment? In terms of the two levels of conditions?
My question to post council is those 4 additional ones. In the prior agreements we've had, all of those that listed your standard choices, and then your 4 additional ones, have those all been listed in the prior agreements?
No, sir. That's a great question, Commissioner Member Johnson. So most of them have. The term regarding probation reports, yes. About specific alcohol or drug counseling, there has not been by this body a direction to complete a specific course or a specific program. So that's the one that I would say has not been. That's numbers 20 and 21. That's a term that this body could choose, but I don't think to date has chosen in prior cases. But in every other instance, these are the terms and conditions this body has recommended and ordered in prior cases.
Including the final one that you referenced.
Including the final one of abstaining from alcohol use, and also including number 22, submitting to drug and alcohol testing.
Yes, I just stick with the same. I mean, maybe maybe for lack of, or to clarify, can you just list what have been in the prior agreements, and then I'll make my motion maybe with more clarity.
Absolutely, and I apologize for making this confusing. There are a lot of options, but absolutely. So with respect to the optional terms, Commission Member Johnson, the optional terms that this body has used in the past would be term 17, criminal probation reports. It would be term 20, or excuse me, term 22, submitting to alcohol or drug testing. It would be term 24, abstain from alcohol use. And then in one case I'm aware of, there was also an additional term 23, which is abstain from controlled substances. So where in that case, I think it was because there were other substances other than alcohol that were at issue. So to recap, I think I'm making it more confusing, but I'm trying not to. To recap, it would be paragraphs 17, paragraph 22, paragraph 24, and if we wanted to add the controlled substances one, which this body has done in the past in a particular case, that would also be term 23.
Then I have to. Got it. So my, kind of.
All right.
You
For
did.
the other commissioner. So my motion is the standard agreements, minus the controlled substance.
I think that's clear. You had a question, Commissioner Moodian?
Officer White, I just have a comment for Officer White. I don't know where the vote will go, but, and separate from this, I just hope you would consider maybe mentoring others who are going through similar challenges, because you can really make a positive difference.
You know, I believe at 22 years as my law enforcement career dwindles, that's the thing I'm going to hang my hat on the most.
All right, we have a motion. We have a second. Commissioner Nieto.
Oh, I was just gonna say my second holds on whatever we decided, so.
I think we're clear on all the standard, and in addition, the second level, except as Commissioner Johnson noted, not the drug testing.
Yes, Mr. Chair, I do think that the record is clear and the transcript will be clear. I'm happy to consult with counsel for the commission to walk through that.
All right.
Commissioner Doring, sorry to confuse this even more, just to clarify that the treatment portion is not included in this, since that's already been completed.
Yes, Commissioner During, you're referring to another separate alcohol treatment. That was not one of the conditions that this body recommended.
Thank you.
We have a motion. We have a second. Mr. Knapp, please call the roll.
Barcelona,
Yes.
Braun,
Yes.
Brazil.
Yes.
Cooper is recused. Doring,
Yes.
Duggan,
Yes.
Gordon,
Yes.
Johnson,
Yes.
Long,
Yes.
Moodian,
Yes.
Moon,
Yes.
Nieto,
Yes.
Rodriguez,
Yes.
Terrio,
Yes.
and Woolry.
Yes.
It's all in favor.
Passes.
Thank you.
Thank you.
Thank you very much.
Thank you, gentlemen. Commission, we're going to look for your direction, whether you'd like to take a break now. Our executive director has looked into his crystal ball and thinks we needed some pizzas, which will be here at 12:30. It's 12:10. We can start the third case now, or we can take a break for 40 minutes. What's the will?
Just do a very short break.
I'm seeing motor through from Commissioner Gordon.
I think people have travel plans.
Okay, that's would be my concern as well.
Excuse myself for 1 minute.
You've got your minute. All right. We'll take a 5-minute break right now. However, 5-minute break back at 12:15 sharp and try to get people back on their planes, trains, and automobiles. It would help. All right. Okay, everyone, our final case today is 2322062 Hector Victorio. The board voted to revoke Victorio's certification unanimously. Post Law Enforcement Consultant Michael Marshall and Carrie Woolley, Post Legal Affairs Bureau, will present the case. Welcome.
Thank you. Good afternoon, Commissioners. My name is Michael Marshall, and I am a law enforcement consultant assigned to the Professional Conduct Southern Bureau in the Peace Officer Standard and Training Accountability Division. With me today is Carrie Woolley, an attorney with the Legal Affairs Bureau. I am here with respect to case post 2322062 regarding Officer Hector Victorio of the San Bernardino Police Department. In this case, the division found reasonable grounds to believe that Officer Victorio engaged in serious misconduct in violation of Penal Code Section 13510.8 B3, alleging that Officer Victorio engaged in physical abuse of a citizen at the conclusion of a vehicle pursuit on November 27th, 2023. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 13510.85 A4, this matter was heard by the Peace Officers Standards Accountability Advisory Board on April 15th, 2026. Following the conclusion of that hearing, the board voted to recommend revocation of Officer Victorio's certification. The division now presents this matter for you to consider, for your consideration of suspension or revocation. As required by Penal Code 13510.85 A5, the record of that proceeding is before you, which includes the agenda and attachments from that meeting, a transcript of the relevant portions of that hearing, and the recommendation of the board. If this matter was heard in closed session by the board, Commission Counsel will be able to advise you with respect to those proceedings. The law requires your review to be of that of the record before the board, which is before you, and which you have had the opportunity to review. To assist you in your review of the record, I will take you through the case as it presented there. As the record shows, I presented this case before the board substantially as follows. Hector Victorio began his career with the San Bernardino Police Department on September 16th, 2021 as a trainee. On March 14th, 2022, he was sworn in as a police officer. This position is defined a peace officer under Penal Code Section 830.1A. On November 5th, 2025, Hector Victorio was demoted to the position of Community Service Officer. Hector Victorio holds the following post certifications. Post Basic Certificate, which was issued March 22nd, 2023. The respondent has not been the subject of any other internal affairs investigations regarding the use of force, nor does he have any prior history of allegations of unreasonable force being filed against him. However, on February 22nd, 2024, the San Bernardino Police Department received a complaint from the San Bernardino District Attorney's Office about an incident that occurred on October 28th, 2023, concerning the respondent's discourteous treatment of an arrestee during an investigation. In addition, in May 2025, the San Bernardino Police Department received a complaint that was submitted by mistake to the San Bernardino Sheriff's Department about a vehicle stop and a residential search that occurred on April 28th, 2025. As a result of these incidents, the respondent agreed to a demotion to a non-peace officer position as a community service officer on November 5th, November 5th, 2025. California Penal Code 13510.8 B3 and California Regulation 1205 A3 defines as serious misconduct, physical abuse, including not limited to the excessive or unreasonable use of force. On November 27th, 2023, San Bernardino Police Department Officer Hector Victorio and his partner were assigned a two-man proactive patrol in a marked unit in the city of San Bernardino. Officer Victorio was the driver while his partner was the front passenger. Officer Victorio attempted a traffic stop on a Kia without a front license plate. The vehicle failed to yield and a pursuit was initiated. The pursuit lasted in excess of 6 minutes, reached speeds of over 100 miles per hour, passed through a school zone, crossed into oncoming traffic, and went through intersections without yielding the right of way. The pursuit ended when the Kia crashed into a utility pole. The suspect of the stolen vehicle, hereinafter referred to as the victim, immediately exited the vehicle and laid face down on the ground with his arms above his head, palms down on the ground in the prone position. The victim had a cell phone and a cash bill in his right hand. We have a picture. Officer Victorio ran towards the victim yelling, quote, "Get the fuck on the ground," end quote. The victim responded, quote, I'm on the ground, bro. I'm not resisting," end quote. As Officer Victorio approached the victim, he immediately began striking the victim in the head with multiple knee strikes after only telling the victim to, quote, "Get the fuck on the ground," end quote. On 3/24/2026, the San Bernardino Police Department submitted additional evidence, which included a video of the sergeant's administrative interview with the victim shortly after his arrest. The victim told the sergeant, quote, "I got out of the car and I instantly got on the ground. I knew I was running from the police, and I knew that I crashed into a utility pool. The next step was to get on the ground, and I got on the ground, and the first thing they did is come up and knee me." This statement from the victim was never documented in the IA report. The statement is consistent with the initial reaction by the victim when approached by Officer Victorio. The victim is heard grunting in pain, and he moved his hands from the ground above his head to protect his face. Officer Victorio followed the knee strikes with multiple punches and more knee strikes to the back of the victim's head and neck. Officer Victorio's partner was on the victim's back trying to gain control of the victim's hands in order to apply handcuffs. The victim kept moving his hands to protect his face from being struck by Officer Victorio. The entire encounter lasted approximately 19 seconds from the time that Officer Victorio reached the victim until Officer Victorio's partner was able to apply handcuffs. During this time, the respondent delivered at least 6 punches and at least 6 knee strikes to the victim's face, head, and neck. One of the knee strikes was delivered to the victim's face while the respondent placed his hand on the victim's head to pin his head to the ground. At one point during the encounter, Officer Victorio's partner used his hand to block a punch from Officer Victorio and then moved his body as a shield between the victim and Officer Victorio. The assault ended as the supervisor arrived on scene and they were able to take the victim into custody. There are 2 different videos of the incident. One video was Officer Victorio's body camera, and the second video was a witness filming from a cell phone. On the body camera, you can hear both Officer Victorio and his partner tell the victim to, quote, "Stop, give me your hands, and quit resisting," end quote. Multiple times, the victim responded by saying, quote, "I'm done and I'm sorry." First video. So this is.
Get on the fucking ground! I'm on the ground. I'm not resisting, bro. I'm on the ground. Stop resisting! I'm not moving. Come on, I'm not moving. I'm not moving. I'm not moving. I'm done. Give me your hand. I'm done. I'm done. Come on, I'm done. Dude, give me your hand. Stop his fucking hand. Stop resisting. Put your hands on your back. I'm sorry. You got him good? Shit. I'm sorry. I don't got nothing on me.
And the second video is the cell phone recording. But I'm going to play this video again in a slowed down, zoomed in video so you'll be able to see what's going on again. Before moving on, did anyone need to see any of the videos again?
Commissioner Terry, can you replay that video again? The slow down version?
The victim sustained a closed fracture of his left orbital socket, contusions to the left side of his face and forehead, lacerations to his lip, abrasions to the right side of his face, and a few chipped teeth. Next slide. So the orbital fracture. Next slide. The abrasions to his lips, the abrasion to the right side of his cheek. Next slide. And the chipped teeth. I also learned from additional videos submitted late that the victim was questioned about airbag being deployed during the accident, damaging his face. The victim said that the airbag did not hit his face because he saw he was going to hit a pole in front of him and brace for impact. This statement was also not included in the IA. The San Bernardino Police Department determined at the conclusion of the administrative investigation that the respondent's use of force violated San Bernardino Policy Section 300.3, use of force. The respondent received 40-hour suspension with 20 hours held in abeyance upon completion of 40 hours of de-escalation techniques and use of force training within 1 year from the date of the signed settlement agreement, which was completed. On January 17th, 2024, the San Bernardino District Attorney's Office declined to prosecute the respondent for a violation of Penal Code Section 149 due to lack of sufficient evidence to prove beyond reasonable doubt. On July 2nd, 2024, the victim signed a settlement agreement with the city of San Bernardino in the amount of $450,000. This settlement agreement compensated the victim for injuries he sustained during the November 27th, 2023 incident. The facts I've just recited support the division's findings that Hector Victorio was involved in serious misconduct, specifically physical abuse. For the purpose of the division's analysts, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Hector Victorio's post-certification be revoked or suspended. The division's recommendation is based on the following. Officer Victorio's actions constituted physical abuse when he used excessive force against a victim who was lying flat on the ground, surrendering, striking him at least 6 times with a closed fist and at least 6 times with his knee. Officer Victorio justified his use of force by stating that the victim was resisting arrest. The subject sustained abrasions to his face, chipped teeth, a broken orbital eye socket during the incident. Officer Victorio completed his training program approximately 14 months prior to the incident. Officer Victorio has been the subject of 2 other IAs, neither of which involved the use of force and were not reported to post as including allegations of serious misconduct. The division believes an aggravating factor in this investigation is approximately 1 month prior to the use of force on October 28th, 2023. Officer Victorio was heard on body camera telling another victim who ran from him, quote, "You're so fucking lucky there's people here. I'd beat the fuck out of you for taking away from me." End quote. And then if you play this video.
You all right? Yeah, I'm fine. Can you sit down? Can I whip on you? Where's the knife at? Is it open?
No, it's not open.
One item 16. We haven't detained. We're gonna be quick here. You're so fucking lucky there's people here. I'd beat the fuck out of you for taking away from me. Just be back quick.
Anyone need to see it again before moving on? During that incident, Officer Victorio threw away the victim's backpack instead of booking it into safekeeping. Inside the backpack was the victim's personal property, 2 cell phones, suspected drugs, along with headphones in a box matching that was stolen during the commercial burglary. The backpack could have potentially contained physical evidence in the incident, but Officer Victorio chose to discard the personal property of the victim and not properly investigate the headphones to determine whether it was related to the commercial burglary. 1 month later, a victim ran from Officer Victorio, and Officer Victorio began punching and kneeing the victim as he lay flat on the ground, which led us to where we are today. Approximately 1 year and 5 months after the use of force incident, on April 28th, 2025, Officer Victorio conducted a lawful traffic stop. During the traffic stop, it was determined that the driver had a suspended driver's license and she had a previous firearm-related arrest. Officer Victorio searched the vehicle and told the driver he would not tow the vehicle or arrest her if she let him search her house. The driver advised that she had ammunition in a drawer in her bedroom. The driver gave permission to search the house, but was left handcuffed in the back of the patrol vehicle while the house was searched. Officer Victorio recovered the ammunition from the house. The driver filed a complaint against Officer Victorio, at which time the department learned the ammunition was never booked into evidence. During the administrative investigation, Officer Victorio informed the agency that he had the bullets in his beat bag, and then he booked them into evidence. Based on these incidents, Officer Victorio was demoted to a community service officer pursuant to a settlement agreement following a misconduct investigation involving violations of policy. Following my presentation to the board, and as documented in the transcripts before you, Casey Castillo, attorney for Officer Victorio, and Hector Victorio provided public comments to the board as reflected in the transcripts. Following my presentation to the board, and as documented in the transcripts before you, one person of the public provided public comment. The board went into closed session. When the board returned into open session, it voted to revoke the officer's certification unanimously, all 6 in favor. With that, I thank you for your time and consideration, and I'm happy to answer questions.
Questions from the commission? Commissioner Brazil.
I have a quick question. On the demotion settlement, I didn't see it in the settlement. Was it permanent or is there a time on the demotion?
But there was nothing in the settlement on the duration of the demotion. I did speak to the IA person in charge, and I asked about the settlement. There is no agreement to promote from that. They have used that with other officers, and they have promoted other officers back.
Okay, so they've reinstated, they have a history of reinstating back from CSL back to officer.
Correct.
Okay, thank you.
Commissioner Terrio, what is the relevancy of adding these other incidents to this particular case? I don't see it in the investigative report.
They're brought in for 1213 factors. It's also part of his service record.
Summary and find, so as part of the investigative summary and findings, that's why we're adding this.
Right. They're also brought in as 1213 factors. They're subsequent incidences.
Okay. And are we provided the extra details behind those? If we're,
Yes, there are attachments.
what part of the attachments are there?
So they would be attachments S and I think it's R, actually.
It'd be attachment P. And
You're right, I'm
F.
sorry. You're right. P and S, yeah.
Can I ask that in the future attachments actually be labeled as to what they are? Because when we get a group of attachments A through T, it makes it very difficult to go through all of them and know what you're looking at.
absolutely.
Any other questions from commissioners at this point?
We'll make sure that happens.
Commissioner Terrio, could I have council explain the factors again for this 12, 13, these additionals? Let's see. Are these items, listed in here? Do they have separate, or I see they do. Yeah, at least if we had page numbers or something, like colleague Commissioner Gordon said, that would be helpful. Sorry, go ahead.
So under 1213, one of the things that is a factor in this is any aggravate or mitigating or aggravating factors. Also, any evidence that there might be a likelihood of recurrence. So it would be any evidence in the officer service records. So one of the things that we pointed out in the ISF for this individual is we brought up that he's had subsequent incidences where he's continued to engage in misconduct, even if it wasn't reported to us as serious misconduct and it hasn't been alleged here as serious misconduct, where he's continued to, even if it's not use of force, there's still incidences where he's had continuing to have incidences. So on page 21 of the ISF, we go over the factors. Want me to go into detail?
That's good, thank you.
Not a problem.
Questions from the commissioners at this time? We'll move to asking whether the subject officer and or counsel wish to comment. Please come forward.
Afternoon. My name is Casey Castillo and I represent Hector Victorio. Thank you for your time. I'd like to address some of your instant questions related to the other instances of misconduct that are before you. The 1213 factors are important, but what is also important is also the proximity or remoteness in time since the misconduct occurred. And I feel that the timeline is important. The scooter video that you just watched was a month before the traffic collision and the pursuit that ended up in the use of force. Hector Victorio was subsequently disciplined for that instance after he was disciplined for the use of force. Subsequently to that was the year later issue related to the consensual search after the traffic stop. So when council mentions that there were subsequent issues related to misconduct, actually what ended up occurring was that there were two issues, the use of force being the second. The discipline almost flip-flopped. Hector Victorio did sustain a 40-hour suspension for the use of force, 20 of it held in abeyance, and then was put through de-escalation training. Subsequent to that, again, there was no further use of force for this individual. One of those 12, 13 factors that I would ask you to review again is the likelihood of recurrence. Before the use of force, there was no internal or external complaints from anyone related to use of force for this individual. And subsequent to the use of force that happened in 2023, there were no use of force complaints for Hector Victorio. The de-escalation training and discipline that was instituted by his department worked. His subsequent misconduct was reviewed by post. We were interviewed on those instances and the matters were closed. At the time of the pursuit that resulted in the use of force, Hector Victorio was a 14-month officer. He had just been off probation for 2 months. He perceived not a cell phone, but a blunt black object in the individual's hand. He approached the suspect and endeavored to take him into custody along with his partner, Officer Rodriguez. The two of them admittedly should have had better communication, and that was the substance of Officer Rodriguez's interview with the post investigator. Officer Rodriguez's perception was not that the suspect was moving his hands to brace himself or protect himself, but that he was also resisting arrest, and it took the two of them to gain compliance and take the subject into custody. Officer Rodriguez also disputed that the movement of his body was done to shield or protect the suspect in any way, and he stated that in his post interview. Officer Victoria extreme support from the members of his department, and I urge you again to read the almost 20 letters of support and public comment that were submitted before the advisory board meeting, to include letters from his captain, 2 lieutenants, 4 sergeants, and his peers. This is an individual who in his short time has had absolutely endured growing pains as a young officer. His demotion was on the heels of a performance improvement plan based on the evidence tagging issue that was reflected in the last investigation related to the consent search. That demotion to community service officer has been in effect for now 7 months. So effectively his department took away his certification as well because he's not been serving in the capacity of a sworn officer. What we're asking for is consideration such that you take no action and allow this officer to continue on the path of learning and growing as a police officer, and or consider a suspension. He's been effectively suspended, but we would also consider that to be appropriate in this particular instance. And I know that he also wants to make a comment.
Good afternoon. I want to say thank you for taking the time to let me speak today. I understand that the videos you guys just watched is very concerning, and I acknowledge that, and I accept full responsibility and accountability, and that's why we went through the disciplinary process. I never gave them any pushback. I accepted that I had shortcomings and that I can become a better person, a human being, a better officer. Like Casey stated, prior to this incident, I never had any sort of problems with use of force, and even the 1.5 years afterwards that I was on patrol, I never had an incident, and I've been in those same situations, if not worse. This experience has been a huge learning experience. Like I said, and like Hasty said, I was only a year and some change when this happened. And I think the amount of experience that I've gained going through the disciplinary process is huge, and it's definitely helped me in my career. Even now as a community service officer, I think I've been able to, even the officers that I'm still in contact with every day, they come to me and for guidance, and I'm proud that through my experiences, I'm able to teach them and hopefully prevent them from being in a situation like this. I've done nothing but better myself since the situation. Those 40 hours of training, I put myself through it. I went back to school, and God willing, in August I get my associates for applied sciences, and I've been doing everything in my power to better and change. And I think I can assure you that what you guys just witnessed will never happen again. I think I've proved that in the year and a half after that I was on patrol, and everything and all the steps that I've taken to better myself since. Thank you.
Any questions of the attorney or the officer? Commissioner Moodian.
Couple questions, Mr. Victorio. I'm just trying to wrap my head around this. So could you elaborate on, I'm trying to, I understand we watched the video, and I understand the adrenaline when there's a chase like this, but could you elaborate on the specific threat the suspect was presenting that justified the strikes to the head?
So, like I said before, sir, the time that I perceived it at that point in time, like I mentioned in my report in my first interview, I perceived it as he was going to get up and push off the ground and get back onto his knees and then continue to evade. I understand now, looking back at it and receiving all the training that I have done, that I could have gone about it a different way, slowed down, conduct a felony traffic stop. But at the time, I perceived it as he was going to get back up and continue to flee from us.
So a follow-up, if I may. So after the first few strikes, what caused you to continue using force rather than transition to a control and handcuffing scenario?
I would say it's inexperience. Like I said, being that close distance, I perceived it as his hands aren't going to his lower back, so he's not giving me his hands. I perceived it as resistance. But you're absolutely right. There's control holds that I could have used.
Thank you.
Yes, sir.
Commissioner Terrio. I'm looking at these 12, 13 CCRs, right? And the vast majority of them, it's interesting that when they're deployed for the use on a case for suspension or revocation, but only certain items are used. But again, the nature and severity of act, this is a very dynamic situation. I think the communication aspect is extremely important. There was definitely a lack of communication. Clearly, people need to be told what to do. It's only fair if they know what commands to be given. If they're not given any correct commands, that's a problem. And I think what you have is an instance where, because of the lack of that, and one officer doing one action, the other officer doing another, then it causes, again, you to react, because this is a tense, dynamic situation and rapidly evolving. And part of the problem, and just a side note too, like, it's not a victim, first of all. He's a suspect. He's a suspect of a 2800. He's a suspect of a stolen vehicle, I guess. So he's a suspect in a crime. You were not charged by the district attorney. He's not a victim. So I want to say that. The peace officer conduct, discipline, and service record, prior instances of misconduct, saying little remarks here and there. I find that to be pretty, again, I don't think they're the right comments to make. I'm sure you've learned that lesson, but to tie those things together like that, I don't know. I think that's pretty weak. the degree in accountability and cooperation. Sounds like you've done a good job of that. The motives that resulted in the conduct. I think your motives were pure. I don't think you had ill intent, and that was something that you set up ahead of time, although that's kind of the presentation that maybe because you said something a few weeks prior that all of a sudden you just go around and that's how you act on every call. I think that's a stretch. Likelihood of reoccurrence. You've been demoted to a CSO. It sounds like this is an agency type of maneuver that is used. I would hope that with that type of demotion, with the discipline that you have received by your agency, you would not choose to do this type of behavior again or communicate better. And so those just my comments to you, and I appreciate your forthwith ability to, accept the actions that you've done and that you are trying to better yourself in that regard. And that I think it's important that, yeah, your tenure does matter. Tenure does matter. It's one of the Graham factors when we utilize force, and sometimes something that is not really kind of taken into account by either agencies or sometimes commissions. And with that, I'd like to make a motion, Chair, to not revoke.
Motion's always in order. Is there a second to the motion?
Barcelona.
I also need public comment, but we've got a request, so we'll hold the motion in abeyance, and at the request of Commissioner Brill, move to close deliberation for a moment.
Customary to go close session.
Yeah, no, I think we should finish the public testimony. We do want to entertain that. Yes.
Chair, I do have a question. You're currently a community service officer, so whatever the commission goes say, you're not revoked. You would have to reapply as a police officer, correct? And go through the whole process again, or would they just reinstate?
I don't know if this is on, sorry. In the past, what has happened is because he is still actively working for the police department, they would do a check to make sure that he hasn't had any adverse law enforcement contact or anything like that. If there is an open spot and the department has determined that he has worked hard, had a good attitude, contributed, which my understanding is he's absolutely a productive member of the department, that it is not off the table that he get reinstated.
But he still retains his basic post certificate at this moment in time.
Correct.
Here, before we move to close deliberation, while the motion is in abeyance, is there anyone from the public who would wish to comment at this time?
I have a quick question, just based on that comment, but it would require, based on post regulations, that he have an updated background.
That is correct. Yes.
Okay. And possesses his post, so he successfully completed probation. I just want to clarify.
That is correct.
Thank you.
Request a comment from Executive Director Alvarez.
He's outside the 180-day window, and it would be a new appointment and would have to go through the process.
Thank you, Mr. Executive Director. Is there anyone who would like to come forth from the public to speak to the commission at this point? If not, we will retire to our deliberation room and be back shortly. We have
My motion will be to suspend for 3 years.
For second,
Second, Cooper.
second for Cooper. Mr. Knapp, please call the roll.
Barcelona,
Yes.
Braun,
Yes.
Brazil,
Yes.
Cooper,
Yes.
Doring,
Yes.
Duggan,
Yes.
Gordon,
Yes.
Johnson,
Yes.
Long,
Yes.
Moodian,
Yes.
Moon,
Yes.
Nieto,
Yes.
Rodriguez,
Yes.
Terrio,
Yes.
and Woolry.
Yes.
All in favor.
Motion carries unanimously. That was the last item on our agenda. Are there any questions or comments before we entertain a motion to adjourn? Anyone?
Brazil adjourn, moved.
Excuse me? Is
Brazil moves for adjournment.
there a second?
Second.
Seeing no objection, after we thank the staff for their excellent preparation, we are adjourned.
Again.
You drive? That one.